to Angela Corey. Angela Corey, the Florida State Attorney overseeing the Martin case. This after the elected district attorney has recused himself for any appearance of impropriety. Ms. Corey, thank you for being with us.
Thank you, Nancy.
It's a pleasure to have you, and you've got a tough job. You have to somehow block out all the screaming, the protests, the this, the that, the TV, the lawyers, the public. You have to look at the facts, and you have to do the right thing, no matter what. Now, maybe I'm wrong, but from those 3 911 calls, it sounds to me like there may be one eyewitness just out of those 3 calls.
I believe you're right, Nancy, and our lawyers are diligently looking into all aspects of the 911 call and the witnesses who called in and may have seen or heard anything.
You know, Ms. Corey, everyone with us, special guest Angela Corey, along with Natalie Jackson, who is the Trayvon Martin family lawyer with us tonight. Also with us is George Zimmerman's friend, Joe Oliver, speaking on his behalf. These are 3 very different interests. Zimmerman, of course, is protecting his own interest as he should. Martin, Trayvon Martin's family, is protecting his interest. With me is Angela Corey, who is looking out for what she believes to be justice in this case. She's representing the state. Ms. Corey, I want to get something straight under the law. Under the law, you may only use force necessary to defend yourself. And we clearly hear Zimmerman. We don't need a witness to tell us that he is chasing Trayvon Martin at the beginning. But now we're hearing a story from his camp that Martin comes back on him, decks him, beats his head on the sidewalk, and then he shoots him. Under Florida law, if that scenario is true, and I'm not saying it is or it isn't, would that then turn Martin into the aggressor?
Nancy, that's a common problem with justifiable use of deadly force as to who is the initial aggressor. As you know from your own experience, you have to look at every detail, every word said, times, distances, everything, the actual gun that was used, and you know that an affirmative defense like this is a very difficult burden for a prosecutor. But I have my 2 top prosecutors on it, Bernie Della Rianda and John Guy. They have been in Sanford every day since we got appointed, which was only 3 business days ago, and they will get to the bottom of all of this.
Well, another question for you, Angela Corey. In my neck of the woods, inner city Atlanta, where I tried felony cases, when there's a dead body, somebody gets arrested, all right? Then they go to jail. If they bond out, good. If they cannot bond out, okay. Then they get to clear it all up at the jury trial. So I don't understand why there hasn't been an arrest, and I'm not saying Zimmerman's guilty or not guilty. I'm saying we got a dead body. I don't understand why the police felt that they had to come to the truth of the matter. That's for a jury, Miss Corey. Am I missing something here?
Only that we have some strict deadlines on once an arrest is made, how quickly charges have to be filed, 21 days basically.
Angela Corey.
Yes, Nancy.
This is how it appears to me. Even if everything Joe Oliver says is true, even if it's all true, shouldn't that be a decision for a jury, not the police department?
Well, Nancy, everything that Joe Oliver said goes to just what we discussed earlier, and it's called an affirmative defense in the state of Florida called justifiable use of deadly force. Stand your ground is a portion of that law, and my lawyers are experts in that area of the law. First, they will go on this fact-finding mission, and then they will look at that law to see how the law applies to those facts.
Mm-hmm. Angela Corey, Florida is not alone. There's stand your ground in many, many jurisdictions. I've got a question about stand your ground. First of all, obviously when somebody comes into your home to burglarize it or rob you or rape you, you can shoot them dead. All right. In a case like this, when you are confronted with force, let's just say for argument's sake Zimmerman's story is true. A 17-year-old hits him. Standing your ground, is he allowed under the law to shoot him dead?
Nancy, our laws are very clear that it has to be a forcible felony and that a reasonable person would have to believe that deadly force is necessary, as opposed to just physical force, fighting back and that sort of thing. I've prosecuted a woman who shot her husband and killed him because he slapped her, and we argued that was not deadly force, and she was convicted and sent to state prison.
Now, what about this claim, Angela Corey, that Zimmerman may have thought Trayvon Martin was reaching into his pocket for a gun? Of course, now we all know he didn't have a gun. Now, sometimes when a victim has a reputation for violence, the law may entertain that theory, but here Zimmerman didn't know Trayvon Martin or his reputation. My understanding, he had a fine reputation anyway.
Everything you just said will be relevant, Nancy, and it's all used. Every aspect of both the shooter and the victim will be looked at and analyzed as it relates to the evidence in this case.